Good morning, everybody. Welcome to this OTC webinar session, The Anatomy of a Criminal Pensions Investigation. I'm Andrew Spink. I'm one of the QCs at Outer Temple Chambers. I'm the head of the business commercial side of Chambers, and amongst my specialties are pensions law, and within that, pensions regulatory law. I've already introduced myself. May I also introduce Michael Bowes, QC, Oliver Powell, and David Grant. We split neatly into two halves in this session. David and I are pension specialists, and in OTC, we have long experience of the exercise of the regulator's powers in the regulatory sphere, Section 38, FSDs, and so on. Some of the well-known cases, and also some that haven't become publicly known. On the other side of the team, Michael and Oliver are very experienced financial crime specialists, and in particular have experience of both prosecuting and defending criminal cases involving some arguably analogous criminal offences in the financial services sphere. What the webinar today is about is the new criminal offences and their largely mirror civil financial penalties, which add to the existing regulatory regime, which already permits the regulator to issue, for example, financial support directions or contribution notices for a range of conduct. But in the case of the existing regulatory powers, against a more limited class of person or target than the new criminal and civil offences. One thing that this webinar is not about are the other new range of powers that are introduced by the 2021 Pension Schemes Act, where additional contribution notice powers were introduced to supplement those already in Section 38 of the 04 Act. And in those cases, if those are successfully exercised once they become available to the regulator, they would have the same result as the existing contribution notice powers. In other words, targeting a narrower range of targets and producing what is in essence a compensatory sum to the scheme that's been detrimentally affected by the target's conduct. Going back to the criminal offences and the civil penalties that we're going to talk about, and also the perspective from which we're going to discuss them, we're going to deal with why the offences and penalties are important. And as you're all aware, and I know that this has caused some consternation in some quarters, not necessarily entirely justified on one view, the new criminal offences and the mirror civil penalties, if successfully made out, would result in the imposition on the criminal side, potentially of imprisonment or a fine, and on the civil side, a financial penalty. These are not, therefore, compensatory, in contrast to the existing and now extended contribution notice regime or the existing FSD regime. Instead, they're punitive, and they're intended to act as a deterrent to behaviour which might detrimentally affect a pension scheme, both because of the serious nature, potentially, of the punishments or penalties available, and also because of the fact that they potentially apply to a much wider class of person, including professional advisors to those directly involved in pension schemes, like trustees or employers, or, for example, banks providing funding to pension scheme employers. Unlike the position under the existing FSD and contribution notice regimes, they don't just apply to the traditional targets like employers and those closely associated with them. The next question you may be asking is, why have this seminar at all? We're very well aware, and indeed have attended a number of very many excellent seminars, talks, and read articles given or written by pensions lawyers, actuarial advisors, or professional pension scheme administrators on what those professionals think the new statutory provisions mean, in what situations they might apply, and how they think the regulator might approach them in terms of whether to prosecute to the criminal courts or seek one of the new civil financial penalties. Senior people from the regulator have also given talks and answered questions about what the regulator's approach might be. By the way, we're delighted to see so many people from the regulator attending this particular session. All of those have made a really valuable contribution to the learning process for those of us working in the pensions world. However, what we hope to offer today is something slightly different, namely an insight into how the new regime, criminal offence and civil penalty, might work when viewed, first of all, through the eyes of specialists in financial crime, like Michael and Oliver, who've got experience of advising clients on both sides in related areas or analogous areas in the non-pensions world. And secondly, through the eyes of specialists in the existing regulatory process, like myself and David, where we've been able to gain experience of how tribunals and courts might approach difficult questions about, for example, what constitutes material detriment. And that experience may be valuable in the context of the new criminal offences and the civil penalties regime. Essentially, we hope we can give some practical advice from a slightly different perspective to that which has already very valuably been given elsewhere. In terms of the topics we'll cover, first of all, we will have some observations on the new criminal offences given by Michael and Oliver. Then we'll have a discussion between Michael and myself about the criminal and pensions law crossover skills required to advise clients in this area. And that will naturally highlight some of the crossover issues that arise when there is an investigation or an actual prosecution. Next, David Grant will deal with the new civil penalty regime. And finally, we'll have a panel Q&A discussion where we'll go through a number of questions that naturally arise from these issues and answer any questions that you in particular have put to us. I hope that will be an interesting format. So that's the end of my introduction. Thank you for listening, and I'm going to hand over to Michael to kick things off.
This is not going to be a law lecture. This is very much practical based about how we think this will pan out in practice, looked at both from the point of view of the regulator and of anyone who may be advising a client or defending in any of these cases. So, two big offences: the offence of avoidance of employer debt and the offence of conduct risking accrued scheme benefits. And in a moment, Oliver will take you through that. Well, are these offences a credible, prosecutable deterrent to pension misconduct? Or, it might be asked, are they perhaps just similar to the offence created in 2013 of taking a decision causing a financial institution to fail, generally referred to as recklessly endangering a bank, Section 36 of the Financial Service Banking Reform Act? That offence, I think most people would agree, is generally regarded as being unprosecutable, and no proceedings have ever seriously been contemplated, let alone. I'm going to say straight away that in my view, the new offences here, the Pensions Act offences, are prosecutable. They are complex, but it can be done, providing the golden cardinal principles are followed of careful investigation, preparation, and presentation. The pensions regulator is a selective prosecutor, and as such can choose between mounting a criminal prosecution or taking regulatory action, similar really in that way to the FCA, and that gives them a large, comprehensive, and indeed powerful toolkit. The pensions regulator can also work with other agencies, such as the SFO. And those of you who follow these things closely might have seen that on Sky News and on the Mail on Sunday, there was a story last weekend about pensions regulator probing the Ralph and Russo collapse and how they were looking at what's happened and have referred to the case to the SFO. So watch this space and we may get some audience comments later. And so really what you'll have here, in all likelihood, is a hybrid investigation which needs a response from the outset, which has a deep understanding of how you conduct a complex criminal investigation, prosecuting or defending, and a deep understanding of pensions law and practice. And so with that headline in mind, I'm now going to turn to Oliver, who is going to take you through the elements of the main offences. Oliver.
Thanks, Michael. Good morning, all. As many of you will be aware, there are already 14 criminal offences which are concerned with workplace pensions. The 2021 Act creates 3 new pension offences, namely 42A, offence of failing to comply with the Section 38 contribution notice, 58A, the offence of avoidance of employer debt, and 58B, the offence of conduct risking accrued scheme benefits. Now, I know some of you will have had reason to look through these already in detail, but conscious that many of you may not have done, we thought it would be useful just to set them out really in very sort of headline view. Now, the 42A offence of failing to comply with the Section 38 contribution notice, as those who do specialise in pensions law will know, previously there was a civil liability for such a failure, or there is now a criminal sanction. This is a summary offence, which means it can only be tried in the magistrate's court, and it can only be disposed of by way of a fine. It is also what we criminal lawyers call a strict liability offence, which means there is no mental element, no mens rea. And in essence, there are 2 elements of the offence. So that is to say, it is for the pensions regulator to prove, firstly, that a contribution notice was issued, and secondly, that the person failed to pay the debt due per the contribution notice before the date specified within the notice. Now, the pensions regulator will need to prove these elements of the offence to the criminal standard. That is to say, so that a court is sure of the guilt. Nothing less will suffice. Now, there is a possible defence to that offence, namely one of reasonable excuse. And in that circumstances, it will be for a defendant to prove that he or she had a reasonable excuse on a balance of probabilities, that is to say, more likely than not. So in summary, in relation to the Section 42A offence, once the pensions regulator has proved to the criminal standard that the contribution notice was issued and that the person failed to pay the debt due in accordance with the contribution notice before the date specified in the notice, the burden will then shift to the defendant. And it will be for the defendant to prove that they had a reasonable excuse on the balance of probabilities for failing to pay that debt. Now, turning, if I may, to the Section 58 and 50B offences. Both offences are what we call either way offences, which means that they can be tried either in the magistrate's court or in the Crown Court. Now, when tried on an indictment in the Crown Court, the maximum sentence which can be imposed is one of 7 years imprisonment and or an unlimited fine. Now, the Section 58A offence has 3 elements, and just distilling those down, if I may, a person will complete the offence of avoidance of employer debt if they, first element, do an act or engage in a course of conduct that does one of the following 4 things. Either prevents the recovery of the whole or any part of a Section 75 debt, prevents such a debt becoming due, compromises or otherwise settles such a debt, or reduces the amount of such a debt which would otherwise become due. So that's the first element of the offence. Second element of the offence, that they intended their actions or course of conduct to have so effect. And third element, that they did not have a reasonable excuse for doing that act or engaging in that course of conduct. Now, Section 58B, again, 3 elements to this offence. A person will commit an offence of conduct risking accrued scheme benefits if they firstly do an act or engage in a course of conduct that detrimentally affects in a material way the likelihood of the accrued scheme benefits being received. Secondly, that they knew or ought to have known that the course of conduct would have that effect. And thirdly, that they did not have a reasonable excuse for doing that act or engaging in the course of conduct. Now, it will not be lost on any of you that there are features of commonality as between the Section 58A and 58B offences. However, unlike the Section 42A offence that we looked at firstly, there is a mental element to the latter offences. So as I emphasised at the time, but for clarity, Section 58A, the person intended the act or course of conduct to have such an effect. 58B, the person knew or ought to have known, again my emphasis, that the act or course of conduct would have that effect. So it will be again for the pensions regulator to prove that mental state. Furthermore, unlike the Section 42A offence, these two offences are drafted in such a manner that the reasonable excuse is actually an element of the offence. That is to say, it will be for the pensions regulator to prove that third facet, that third element of the criminal offence to the criminal standard, unlike in the 42A offence, where we have that reverse burden. I'm now going to pass over to Michael and Andrew for some discussion.
Oliver, thank you very much for that. Now, all of you will have noticed in relation to these offences that there is no element of dishonesty which has to be proved. But the draft guidance makes it clear, in my view, that prosecution is more likely in cases which I would style as being at the fraudulent end of the range. As I quote, "We will select cases for prosecution being mindful of the policy intent behind the new offences, for example, where the primary purpose of the conduct is the abandonment of the scheme without provision of appropriate mitigation. Significant financial gains have been unreasonably made to the detriment of the scheme, and also taking steps to bring about the unnecessary insolvency and stripping of assets from an employer." To put it in simple Southwark jury terms, the guidance makes it plain, doesn't it, that there has to be an element of plunder before really it'll be worthwhile bringing a criminal prosecution. And I have to say, I think that would be sensible. So the offences contain complex elements and they will be challenging to prosecute. They undoubtedly contain elements which require expert understanding of pensions law and practice, and to me it seems inevitable there will be expert evidence called by the prosecution, and certainly the defence will be consulting an expert too. And this is really, it seems to us, the area where either side is going to need really well-honed crossover skills. Let's look, and I'm going to do this with Andrew in a moment, at three particular aspects of the new offences. One is material detriment, which is an element of both offences. Two, in the 58A offence, the prosecution must prove, bear in mind, no reverse burden, prosecution must prove that the person did not have a reasonable excuse for doing the act. The jury won't have the pensions expertise, so of course they're going to need expert help on this. And then under 58B, after material detriment, the person knew, and now listen to this, or ought to have known that the actual course of conduct would have that effect. Again, inevitably, straight into an area of complex expert evidence, and the teams are going to need to have on both sides those skills. So Andrew, straight over to you now, particularly around these concepts which you have come up, but across a lot in pensions law around material detriment. And then we can also look at reasonable excuse and knowledge or ought to have known. Andrew.
Thanks, Michael. Yeah, I agree with everything you've said. On the end of the spectrum that might be open to prosecution, I ultimately would probably defer to your view in terms of that, because of your experience of seeing prosecution decisions in the financial services world, for example. I think your explanation of where the most likely prosecutions are likely to come is probably correct. Certainly, if there's an element of plunder, that would be plainly within that area. I have seen over the years a number of cases which have been dealt with through the existing regulatory regime, where the conduct has been bad, and the question of whether it's plunder or abandonment is perhaps a moot point, and may ultimately come down to the same thing, because if you abandon a scheme, you're doing so probably for financial reasons. So I think with that little gloss, I'd probably agree with you. What's interesting about these offences, from my perspective, is the fact that they follow in many respects, or employ concepts that we're quite familiar with in the regulatory world, in the Section 38 world, obviously. The material detriment point is an important one, because material detriment has not in fact come up before the determinations panel and the higher courts for consideration very much at all. It's been, in my view, an experience increasingly used by the regulator as a route to imposing a penalty. But I think it's fair to say that the scope, the limits, the meaning, and the application in certain important situations is still relatively unclear. And it seems to me that in a criminal prosecution, what is or is not material detriment as a matter of mixed fact and law will be a difficult question on which I wish any jury who has to deal with it a certain amount of luck, because I think it's an area where in the regulatory sphere, a considerable amount of expert evidence has been put in by both sides in regulatory proceedings where this has been an issue, from covenant experts and other financial experts, in addition to the complicated submissions on the law that go with it. I've seen that very much in recent big warning notices where this has been an issue. So I think that there will be challenges. It's perfectly capable of being overcome, but there will definitely be challenges. And as for reasonable excuse, it has resonances, doesn't it, of the Section 38B defence in relation to the traditional regulatory world, which again is an area where there's not a huge amount of certainty about the precise scope of that as a defence, and the same I think will apply in the criminal context. The difference here, of course, is that the prosecution has to prove no reasonable excuse, but what is a reasonable excuse is likely in many situations to call upon concepts of how people behave in the pensions world, what the professionals are trying to do in a particular transaction, for example, why they're trying to do it, what the reasoning behind that is. These are complex, factual, expert issues that juries will have to get to grips with. And I think that's, as I say, a challenge. And I agree with you that if one is advising a client who might be facing prosecution, or perhaps advising a prosecutor on whether to prosecute, there is scope for advice both from criminal lawyers experienced in this field and pensions lawyers because of the concepts that are transported from the existing regulatory regime.
Right. Thank you very much for that. We're going to move on to interviews under caution. Now, although the regulator is a selective prosecutor, if it reaches the stage it wants to question someone, which is pretty inevitable, it must caution them if it has reasonable grounds to suspect that a criminal offence may have been committed. And that's really important. That's there for the protection of the suspect. And so that could occur quite early on in an investigation. And you've then got the critical questions, if you're representing that person, as to what's the best way of approaching that in relation to a complex investigation. Oliver.
Thanks, Michael. Now, as you'll all be aware, by virtue of Section 72-78 of the 2004 Pensions Act, the pension regulator has a variety of powers. And I think probably the pension practitioners in the room will be most familiar with the TPR's ability to issue a Section 72 notice, compelling information from individuals and corporates. But really, what I want to focus on is an area probably where you'll be less familiar. That is to say, the powers to conduct a PACE interview, that is to say, an interview under the Police and Criminal Evidence Act. Now, as Michael's already touched upon, and really sort of maybe stripping it back and going back to basics, in circumstances where the pensions regulator has reasonable grounds to suspect that an individual or a body corporate has committed a criminal offence, it should interview the suspect under caution. And that interview should be undertaken, as I've already alluded to, in compliance with the Police and Criminal Evidence Act and, of course, the accompanying codes of practice. Now, I think from the outset, if the pensions regulator contacts your client, it is very important to ascertain from the word go whether or not the person of interest is actually a personal individual, private individual, or whether or not it is a body corporate. If it's the body corporate, then what you will have to do is, under instruction, is actually ascertain who is the most appropriate person to give evidence, or provide attend a PACE interview and give evidence, to talk to the issues that may come up. And in that sort of circumstances, it will obviously be important to ascertain what the likely issues are, and choose the most appropriate person to speak for and on behalf of the company. But what does a PACE interview actually mean in reality for those non-criminal lawyers online? Well, in essence, it means that a suspect is cautioned at the start of the interview. It means the suspect is entitled to have legal representation. So you as a solicitor is entitled to be there with them when they're being interviewed, and to advise them at different junctures as there are breaks. The suspect is entitled to exercise his right to silence, and we'll come on to that in a moment, if I may. The suspect, of course, is entitled to have regular breaks during the interview, and the interview should be recorded. Now, the reality of the situation is, when your client, be it a body corporate or an individual, is notified that they are going to attend an interview under caution, the first thing you should be doing is obtaining pre-interview disclosure from the pensions regulator. And the importance of that is it will inform the approach that you will take to the interview. And what I mean by that is, having had sight of that pre-interview disclosure, you will be able to, at maybe very high level only, but you'll be able to understand better the issues which the pensions regulator seek clarification on. And you'll be able to speak to, if it's a company, the right people. If it's an individual, obviously you'll be able to advise them on their legal rights, and the approach you take. And the approach you take is really, really important, and it's not something that should be taken lightly. Broadly speaking, you have three options when you attend an interview under caution. Your client either can give a full comment interview, that is to say they attend and answer each and every question that is asked of them. Similarly, they can give a no comment interview, which means they simply, as you've probably seen on TV, just say no comment to every question that is asked of them. The drawback of that, and one of the reasons why there are very good reasons not to take that approach, is should the matter ever proceed to trial, so that is to say, should the pensions regulator charge or summons your client, then the judge at a trial can direct the jury that an adverse inference should be drawn. That is to say, why is your client now relying on certain matters of fact that were not canvassed previously at the interview under caution? And the third approach is that your client can actually read out a prepared statement at the outset of the interview and then follow that by way of a no comment. And the third option is, I have to say, as someone who regularly advises companies and company officers, that's my preferred approach. But I have to say, it is not a question of one size fits all. Different cases will require different approaches. But I think the third approach is attractive, if I may say so, because what it means is you have a level of control on the narrative, but actually, hopefully your prepared statement is full enough that you can actually preempt some of the questions that the pensions regulator may ask of your client. Therefore, you're not leaving and exposing your client to an adverse inference further down the line. So that they are really sort of a bit of an overview as to a PACE interview. So in terms of my probably three top tips for a PACE interview, I think one, make sure you get pre-interview disclosure and take instructions, brief your, make sure your client fully understands the ramifications of attending an interview. And of course, whatever the pre-interview disclosure throws up, that will inform the approach you take, be it full comment, no comment, prepared statement. Second bit of advice really for a PACE interview, or top tip, is as a solicitor, remember your role there is to ensure that the questions that are being asked of your client are relevant, and indeed that the interviewing techniques are appropriate and not oppressive, although I think that's highly unlikely with a professional regulator like the TPR, and also that PACE is complied with, that is to say regular breaks are adhered to and such like. And it's not so much a specific tip around a PACE interview, more as where there is an extant ongoing investigation. Have the confidence when you're dealing with the regulator to bottom out whether or not your client is being dealt with as a witness of fact or as a person of interest, that is to say a suspect. and having the confidence, if there is a little bit of ambiguity, and that's not uncommon, the default position, which the TPR would undoubtedly follow, but don't be afraid in the polite way of informing them of this, is that if actually your client is somewhere in between, in the first instance, they should be interviewed under caution. If it transpires further down the line that they're actually just a witness of fact and they're not a suspect, then they can always provide a Section 9 witness statement. But the default position should be that it's an interview under caution as opposed to what we call a Section 9 witness statement. Anyway, that's a very quick whistle-stop tour of interviews under caution.
Thank you, Ollie. That's really helpful. We're going to move on to financial penalties now, the parallel new regime. David, over to you.
Thank you, Andrew, and good morning. So we move from criminal conduct to a quintet of penalties, which rather encapsulates events at Wembley on Sunday. And while all the discussion in the press by stakeholders has been on the criminal aspect, and understandably so, it seems to me that the financial penalties are of considerable interest for a number of reasons. So to start with, there are 5 new sections headed financial penalties. They break down into two categories. The first category are the 3 which are equivalents to the new criminal offences, which Michael and Oliver have spoken about. So Section 42B provides a financial penalty for a failure to comply with the Section 38 CN. That's the equivalent of Section 42A. Secondly, Section 58C provides a financial penalty for the avoidance of employer debt. Thirdly, Section 58D provides a financial penalty for conduct risking accrued scheme benefits. Those 2 are the analogues of 58A and B, the triable either way offences. The second category is slightly different. We have at Section 80A a financial penalty for providing false or misleading information to the regulator. That is the equivalent to existing Section 80 in the 2004 Act. And finally, we have perhaps a new category of its own, Section 80B, which is a financial penalty for providing false or misleading information to trustees or managers. That's unusual because it doesn't correspond to any criminal offence, whether existing or new. It's a self-standing provision, which doesn't have any criminal equivalent and raises a number of questions as to the breadth of its scope. Now, going back to the 3 which have criminal equivalents, broadly, the financial penalties have the same elements, but there are some differences. So Section 42B talks of a financial penalty for failing to comply with the Section 38 notice. It repeats the language of without reasonable excuse in Section 42A. That textual similarity rather departs when one looks at Sections 58C and D. In 58A and B, the person in question has to do an act. 58C and D, the language is of a party to an act or deliberate failure to act. Similarly, Sections 58A and B talk of there being no reasonable excuse. That language is departed from in Sections 58C and D. The language instead is whether it's not reasonable to act or fail to act. There are many more textual differences, and some of those will doubtless have to be looked at very carefully in due course in any real case, but we don't have time to discuss them at the moment. Those are the 5 new financial penalties. Section 88A also applies in 2 other circumstances. First of all, Section 69, which imposes a duty on an appropriate person, which is primarily a trustee, to notify the regulator of certain events. That replaces old Section 10 of the Pensions Act 1995. And in the case of a failure to comply with that, Section 88A applies to a trustee or a manager who has failed to take all reasonable steps. The final application of Section 88A is a new Section 69A introduced by the Act. That's a new duty to give notices and statements to the regulator in relation to certain events, effectively giving notice to the regulator of a notifiable event. And the failure to comply with that can give rise or engage Section 88A. Now, there are various points to note in relation to this financial penalties regime. First point, under section 88A, the same £1 million maximum penalty applies whether or not the criminal equivalent is summary only, section 42A, which yields only a fine, or is a triable either way offence, section 58A and section 58B. Secondly, under section 88C, a penalty under section 88A is recoverable by the regulator, and the regulator must pay the penalty recovered into a consolidated fund. That's interesting for reasons we may go on to discuss. Thirdly, there are provisions in section 88A brackets 9 to do with recovering a penalty from a body corporate and a director, and that's led to some speculation about whether it's possible to do both. Fourthly, the regulator cannot issue a notice under section 88A to a person in relation to an act if A, the person has been convicted of an offence, or B, there are ongoing criminal proceedings. That gives rise to the question of how the regulator is going to choose between the criminal route, the civil route, and the circumstances in which it can move from one to another. Fifthly, the process for imposing a financial penalty is similar to the existing process for civil penalties. There has to be a warning notice with a minimum period of time. And the question as to whether a penalty is to be imposed is to be determined in the first place by the determinations panel, with an escalation thereafter to the upper tribunal and potentially to the Court of Appeal on appeal therefrom. And sixthly and finally, we await a new policy on monetary penalties. The one from the regulator is a few years old now. We're told that one will be forthcoming. I'm not exactly sure when. But the one thing the regulator has said, as recently as a couple of days ago, is that it anticipates that the maximum penalties will be imposed rarely. So those are my 6 introductory points, and I'm going to hand back to the others for more general discussion.
David, thank you very much, and thanks to all my colleagues for their comments so far. What we're going to do now for up to about 25 minutes, which will take us to the hour mark, having started just after 10, is to have a discussion about various issues that we think arise out of these points, based on questions and answers. And we have various questions already on both the criminal side of the regime and the civil penalty side of the regime. Some of these are to do with policy and the overall powers. Some are more technical, and there's a considerable degree of overlap. Broadly speaking, I think I'm going to start with the questions that deal with policy and overall powers. But before I get into those questions, we have had one specific question that's come out of Ollie's discussion of interviews. And Ollie, I don't know whether I can get you to have a go answering this straight up, because I think it may stimulate some thought amongst our audience. And I think it's significant that one of the first questions we've had that's come live during the webinar relates to this. The question is as follows: on the theme of regulatory interviews, do the panel think TPR's new investigatory powers to compel people to attend interviews not under PACE will be widely used, as they are by the FCA, for example?
I think I can deal with that shortly and say yes, I do think they will be. And you know, the author is absolutely right. The FCA make very good use of them, as do a number of other regulatory investigators. What I should say, just by way of sort of clarification, really, is ordinarily any statements which are obtained through powers of compulsion are not admissible in criminal proceedings. However, there is an exception to that without overcomplicating matters, in circumstances where there are co-defendants and things that have been said. So I think the answer to the question is yes, and ordinarily they will not be admissible. But the slight fly in the ointment is there is a sort of an exception. Yeah,
and there's a follow-up question which has just come in, which I think I probably should put if I can, because it follows on from exactly what you've just been saying. Correctly, one of our attendees has pointed out that there's protection afforded by Section 310 of the Pensions Act 2004 against the use of compelled statements against a person in criminal proceedings unless the person first raises them. Where an investigation is started into a company and a director or senior officer gives answers in a PACE interview, does this leave the company with no protection under Section 310? Also, does this mean directors can be compelled to give evidence against each other so they all get prosecuted anyway? Now, that's a very specialist question, but is there anything you think you can usefully say about that at the moment?
Michael, do you want to tell that, or do you want me to?
Yeah, no, I'm happy to do that. There will be a fork in the road for the regulator when conducting an investigation. Is this now going down a criminal route, albeit alongside regulatory, or are we simply only interested in regulatory? Once you open a criminal investigation, particular obligations start to play with the Criminal Procedure and Investigations Act, particularly in relation to disclosure, retention of material, and so on, and the obligation to caution. And where the suspect, if I can put it that way, is a corporate and a person who's there to speak on behalf of the company is interviewed under caution, that will have to be made plain. And the regulator will have to be very careful not to trample between the two forms of investigation and to muddle the use of various powers, because it would be quite wrong for interviews given or answers given under compulsion to then be sought to be used in that way against a corporate when that person wasn't speaking on behalf of the corporate. And so it will be essential for those advising corporates and individuals to make it plain right from the outset, what is the status of my client, corporate or individual, and which route are you going down at present? Is this compelled? Is this under caution? And to make sure that those safeguards are in place. I don't think it's going to be possible in any way for compelled interviews to be used as some device for getting round interviews under caution.
And can I just follow that as an adjunct, really? Whilst, as Michael said, the starting principle is obviously any interview under compulsion is not admissible in criminal proceedings. What I routinely see in the financial services sector is that obviously that informs the investigation. So that information inevitably leads to certain lines of inquiry. So even if they can't use that evidence, they have an understanding maybe about what has happened or the kind of evidence they might need to obtain. So they will then seek to obtain that evidence lawfully, which is admissible, from another route.
I'm going to take us back to some higher level policy issues right now, starting with the criminal regime, but I want to move quickly in a moment into questions about the civil penalty regime. To some extent, I think Michael and I have already hinted at the answer to this in our introductory words and in our discussion, but do the panel think that the new offences, the new criminal offences, will give rise to a large number of criminal cases being brought by the regulator? And allied to that, perhaps, is another way of putting that, a slightly different but a similar way of putting that question: are these new offences going to turn the regulator into the pensions police? Ollie, do you want to give us a go on that one?
Yeah, of course. Thanks, Andrew. I think that the reality is, as has already been touched upon, the pensions regulator are not a high volume prosecutor. You know, they are very much a single figure prosecution every year organisation. And for my part, I expect that to continue. And probably dealing more with the second question. Whilst the new offences will be used, in my view, to strengthen the pension regulator's regulatory grip and indeed the options available to it, I do not believe that they are going to turn them into the pensions police. I mean, I think as David Fairs has said sort of publicly, from the pension regulator point of view, there will not be an immediate uptake in the pension regulator's prosecutions. And indeed, I think from his point of view, there's sort of, if I can put it this way, an aspirational hope that actually the mere existence of these powers will actually deter wrongdoers from doing wrong.
Yeah, I mean, I think we will see a number of investigations open. I made reference to the Ralph and Russo investigation, which is already open. And also, particularly from those who are representing individuals or corporates, you've got to understand that it's not just a question of, well, in the end, will this be prosecuted? It's all the interim steps during an investigation, particularly if you're defending, being able to satisfy the regulator very early on there really is nothing here to look at. It's a very little comfort to your client to say, don't worry, in 6 years' time, the jury at Southwark will get this right. They will want to bring the proceedings to an end at the earliest possible opportunity. And so the strategy needs to be worked out right at the outset with combined skills. This is what the regulator is concerned about. How best do we approach it? And Andrew, that's where I think the crossover skills are going to be absolutely essential right from the beginning.
Yeah, I completely agree. And also this immediately brings into focus the existence of the civil penalty regime alongside, because the regulator's got a choice and there are questions about how it will make that choice and when it will make that choice, and when and how it's going to communicate that to its to the people that it is investigating. And I want to just, if I may, in order to give some color to that particular discussion, ask David a couple of questions, if I may, about the civil penalties regime, and then segue from that, Michael, into asking you about some of the ways in which you think the regulator might make these choices. David, there are a couple of questions here, which I think are a pair. First of all, why have the financial penalties regime at all, in addition to the criminal offences, given that the elements are the same? And secondly, given the resources that are available for the regulator to seek to impose a financial penalty, and the fact that the proceeds are paid into a central fund, what's the incentive for the regulator to go down that route? And I guess that is a question about that route rather than prosecution, but also that route rather than try and fit it into the existing contribution notice regime. Do you have some thoughts on those points, David?
If you're from the Sir Humphrey Appleby School of Public Service, for the Prime Minister fans amongst you, you might consider that new powers are to be enjoyed rather than exercised. But I think the reality of having financial penalties alongside the criminal powers is revealing. First of all, is it a sort of tacit admission that these offences are going to be difficult to prosecute? What is the real difference between having a financial penalty of £1 million and being convicted of a criminal offence and a fine being imposed of a similar sum? Of course, you avoid the finding of criminal conduct, which is not insignificant, whether you're an individual or a body corporate. But as you said at the outset, Andrew, it's still a punitive power. This isn't compensatory. And the reality may be that, leading on to your second question, the incentive for the regulator to go down potentially complex proceedings of establishing the requisites to impose a financial penalty, that the rationale for that is to send out a message to the marketplace and to encourage the others in the hope that they won't have to do so in the future, once it's clear that the regulator will not shy away from exercising these new powers. Perhaps stakeholders out there will realise that their conduct is open to potential scrutiny.
And I suppose the hurdles that the regulator needs to get over under the civil penalty regime are lower. The standard of proof is lower. It's the civil standard of proof rather than the criminal standard of proof. And also procedurally, the civil penalty route will be taken to the determinations panel of the regulator, which is a tribunal and a venue with which the regulator is more familiar from its regulatory experience, as opposed to having to go in front of, for example, a jury in the Crown Court. And it might be that that is a factor that is taken into account by the regulator in deciding whether to go down the criminal route or the civil penalty route. I think I'm going to move on to the question that I foreshadowed, Michael, if I may. Whose decision will it be whether to go down the criminal route or the civil route? And obviously taking into account that there is more than one agency that can actually bring criminal proceedings, the regulator not being the only one.
No, certainly. It is restricted, though. Criminal proceedings can only be brought by the regulator, the Secretary of State, which won't happen, or by or with the consent of the DPP. So theoretically, it could be CPS or even could be Serious Fraud Office, though I doubt they'd rush a pure pensions case, but they might. What you can't have here is a private prosecution, and that's very important. Unless an Act of Parliament says you can't have a private prosecution, you can. But here you can't. It can only be done by someone who's authorised to do it. Let's assume it's the regulator. The regulator will have to decide quite early on, has this the potential for a criminal prosecution, in which case all the time you've got to decide, are we opening a criminal investigation? The moment we do, it's got to be CPIA compliant, it's got to be PACE compliant, even if in the end we don't prosecute and we go down the regulatory route. These cases will be expensive to investigate and expensive to prosecute, and it will be vital that the right decision-making exists throughout, including, of course, disclosure. But ordinarily, once, say, the regulator has begun, it will be for the regulator to decide, applying the Code for Crown Prosecutors, evidential test and public interest, do we go or not? And as I say, to put it in really simple terms, my gut feel is that unless it has an element of plunder, prosecutions won't be brought.
How long do you think the regulator can keep all the balls up in the air, so to speak, in an investigation? Or in other words, by which I mean the potential for a criminal prosecution or going down the civil penalty route, or indeed the traditional regulatory route?
Yeah, well, it can run both, probably for, if it needs to, for a number of years. I mean, SFO investigations routinely take several years before a charging decision. This is the point about defending. That's a nightmare, obviously, for your clients, and therefore we want to bring it to an end at the earliest stage. But what the regulator or any prosecutor's got to be careful about, and particularly the regulator here having the hybrid powers, is not shutting out the criminal route if that might apply. In other words, making the wrong decisions early on, simply using compulsory powers, etc., and thinking later, that was unfortunate, we didn't really think. Now what we've found is this looks more like a criminal investigation. So early consideration.
Can I add something to that, which picks up on something I mentioned earlier? So under section 88A brackets 10, the regulator can't issue a notice under section 88A to a person if that person's been convicted of an offence or is undergoing criminal proceedings. Now that may well, as Michael intimates, give rise to the opportunity of the regulator hedging its bets for as long as possible, not wanting to commit itself too early for fear of then not being able to reverse that decision. Yeah,
but it can't be a sort of in-out process. You could reverse a criminal investigation decision, but in a sense, once you're doing that, if you make the decision it's purely regulatory, you're closing down the investigation. And that could come around settlement. One of the points you might want to consider is plea bargaining to some extent. Might those representing people under investigation say, well, what about the civil route only, the regulatory route? Of course they can. That happens routinely with FCA.
And is that something that in the financial services world is conventionally proposed from the defence side, as often as it might be perhaps from the prosecutorial side, or do people wait to hear from the prosecutor on potential?
I don't think you can build it into convention. Both can apply. No. It's so much fact specific and a question of feel in each case.
But in principle, there's nothing to prevent a proactive individual or corporate under investigation, properly advised from the outset, trying to deal in that way with the prosecutorial authority. Is there?
Absolutely, and it could be a very attractive outcome in that way, much quicker. Everybody clears it up and it's over. I could see that happening quite easily.
Okay, I'm going to move us on to a slightly different area. Always love a question about legal professional privilege, and we have one. I think this is, I suspect this is probably for you and Ollie, because I think you may have come across this in the prosecution world, in the financial services arena. The question is as follows: if the regulator commences a prosecution against a solicitor or counsel, well, that's plainly never going to happen. But if it were to, the defendant's ability to defend themselves, that's the defendant lawyer's ability to defend themselves, is highly likely to need to draw upon and rely on the privileged legal advice they gave their client. The privilege, of course, is the client's. If the client's not prepared to waive the privilege, how can the legal advisor defend themselves fairly? NB, the same issue obviously does not affect other professionals, e.g. actuary, covenant advisor. Any thoughts, chaps?
I mean, that is a good question. I mean, again, it's very, very fact specific. In terms, it's hard to think in those circumstances of how a solicitor potentially is liable where the individual under advice is not also liable, in which case they may be saying that the crime fraud exception applies, but actually this wasn't privileged at all. You were actually advising in the pursuit of a criminal offence. I find it very hard to think of circumstances in which the client is somehow not involved, but the solicitor is. It's much more likely, it would be said, the solicitor and the client are complicit together, and that therefore the crime fraud exception applies. This was never privileged advice at all.
Yeah, sorry, Michael.
No, not at all. I was just going to say, I agree with Michael. I mean, privilege is a notoriously knotty issue, as I think we all know, and Michael and I deal with a lot with internal investigations. I think it's important for everyone just to remember there are a number of notable exceptions and caveats to privilege. And as Michael said, the iniquity fraud exception being one of them, but also better right of another party, particular relationships, and also there are statutory exceptions. So I think it will be very fact specific. And as Michael said, I think you'd be surprised given the circumstances. I think it's unlikely to arise anyway.
We've had a quick question, guys, about deferred prosecution agreements, which is an SFO creature. Is there any scope for something like that in this context or not? Maybe one of you could explain to the uninitiated what a deferred prosecution agreement is, if it's relevant at all in this space.
Yeah, I don't. As far as I'm aware, these offences have not yet been added to the list of offences for which a deferred prosecution agreement can exist. The procedure is there in relation to a corporate, of course, only an agreement between the prosecutor, normally the SFO, and the defence, which then has to be approved by the court as being in the overall interests of justice, which enables the corporate to avoid having a conviction, but results in various financial penalties and particularly remediation. Around a corporate, which is charged, that in future, that could be a good idea. I would expect that to see extended. Of course, it cannot apply to individuals. And sometimes here you're going to be dealing rather more with individuals who are alleged to have plundered rather than a corporate.
Thank you, Michael. Ollie, I assume you probably don't want to add anything to that. No, thank you. Well, we're just getting beyond 11, and I was going to end with a slightly more technical question. David, if you could possibly give some thought to this, and anyone else as well who wants to answer it. It relates to the civil penalty regime. Now, I said earlier that, of course, one of the advantages for the regulator potentially in going down the financial penalty route rather than the prosecution route is that the civil standard of proof would apply. Is there any argument at all that the threshold of beyond reasonable doubt might be held to apply to the civil financial penalty regime, given that there is no direct express reference to that in the Act?
Shall I go first, and then I'll be corrected if I'm wrong by the others? I've heard there's been some speculation about this, and some people very recently have pointed to analogies with prosecutions under the Housing Act, I think section 249A, but the wording in that case was very specific and included the words beyond reasonable doubt. Now, the absence of those words here one would think suggests that the fact that it's the normal civil version of proof, and that absent some express words saying that this has to be established beyond reasonable doubt, other things being equal, the normal civil burden would apply.
Michael, Ollie, you want to add anything to that?
I agree, civil burden.
Okay, end of debate. And on that firm and clear answer, I think at 11:03, having detained you all for an hour, thank you very much indeed for attending. I see from our numbers that they've held up very well right to the end. We're very grateful to you, and hope you found it interesting and stimulating There are obviously lots of questions that are unanswered, but maybe we've started to answer a few of them. So on that note, I'll say goodbye and thank you very much.